You have to wear makeup.
We'll assume that.
All right.
All right, I will call this study session to order. We will not take attendance, but it looks like everyone is present. Today we're here to discuss our Littleton liquor processes and licensing processes. We have Paul from the City Attorney's Office to walk us through some training. So with that, Paul, the floor is all yours.
All right, so this is entitled Liquor Authority Board 101, but really it's probably more like the first lecture on the first day of Licensing Authority Board 101. So we're not going to go too deep. It tends to be when something comes before the board, the relative provisions and all that stuff are put together for you, so I don't want to spend a whole lot of time on that. So you have two functions, licensing over liquor and medical marijuana. As somebody pointed out to me today, we have, council has not authorized retail marijuana for recreational use, only medical marijuana. We had 4 dispensaries, we're down to 3. One of them went out of business. So apparently medical marijuana may be a dying industry, but we'll see what happens. So your powers come from really 2 sources. The municipal code has some provisions as to what the licensing authority does and what the provisions are, and those must be consistent with state statutes and the liquor code, the beer code, and the special permits under the Colorado revised statutes. So your powers are really 3. Grant or refuse licenses, and that could be for different kinds of licenses. Make general rules and findings with respect to the proper regulation of the industry. And I understand from Colleen that you guys, some subset of you guys, did this recently and they've updated the code. So there probably won't be a whole lot of that in the near term. And then hear and determine at public hearing complaints against licensees and decide if there should be some sort of consequences for any violations of the liquor code. So also have to complete records and of all the transactions and stuff. I'll lean for that.
On the complaints, we have the right to revoke the license or refer it to the city council to revoke the license.
You can revoke because you granted it. It's your authority. Okay. So, or any other limitations or.
Right, council does not have purview over liquor and marijuana licenses.
They did before this authority
They
was...
did, and then they created the authority so that they would not have to hear those licenses.
So you guys are powerful, almighty, all powerful.
Yeah.
And then there's, other record-keeping notices of renewals and things like that, and that's mostly what Colleen does. These are the provisions of the municipal code that control the medical marijuana center licensing. Haven't had any in a while either, right?
MMC centers?
Yeah.
No. The fact that the city is limited to 4, and we do have buffer zones where they're allowed to be. Yeah. The one that recently ceased operation was in a non-conforming location. So even if they had opted to transfer their license, that new applicant would have had to apply and find a conforming location. And we really only have one small area left, and it's a built to suit. So
I don't expect us to be having a whole lot of those. From the statute, though, these are the things that you're allowed to consider for licensing. And I know this came up at the last meeting when a member of the public wanted to talk about, compliance with the zoning code and things like that. And we kind of said, all right, well, that's not within our purview. So we asked, what are the reasonable requirements of the neighborhood? What is the desire of the adult inhabitants, usually through petition or somebody doing some sort of surveying, and that's pretty standard stuff. And then any other reasonable restrictions that are or may be placed on the neighborhood by the licensing authority. Now, I think there would have to be some fairly unique circumstances, but it could happen.
Well, some municipalities will pass local legislation for undue concentration of certain types of licenses. We have not done that.
And that's the last one, there is a undue concentration under the statute that would result in require additional law enforcement resources, but I suppose if the police department is going to make this claim, they would be part of the presentation and let us know. It really isn't part of what we do here.
Is there case law that interprets can you go back one slide, to what other reasonable restrictions are?
I'm sure that there are, and they're probably all case-by-case determination under the unique circumstances of the facts. But, if we get to one of those and we need to do that, that's where I'll kick in and, we'll pull some things together. We can table the application to another day and I can, prepare a memo for you or something. So that's where I kick in.
On the one board I attended, we talked a little bit about other liquor licenses that are in that general area, but I don't see that up there. Or is that meaning just because there's one across the street? Is it just because of the reasonable requirements of the neighborhood? Is that what reason
I
matters?
think it is a consideration because the needs and desires of the neighborhood.
I see.
So it's a component of that, or if the adult inhabitants say, there's already a liquor store at the end of the block, we don't need one across the street, then they might say, or it might have a lower response rate for the survey. But so it kind of backdoors in that way, I think. That's a good question.
But there aren't any zoning restrictions that
No.
California, as I understand it, has there are limits on how many liquor stores can be in a certain geographic area.
Well, that's also because in California, they have a limited number of licenses that
Sure,
actually go
yeah.
up for auction.
We don't have any restrictions like that, as I
Right.
understand it. So
Recently with Colorado, though, there is a 1,500-foot buffer between retail liquor stores. But I remember there's a little complication when it comes to a 3-2 license.
Well, yeah, so fermented malt beverage now, because they're not 3-2.
But wasn't that buffer made so King Soopers couldn't just put one in when there's a liquor store in the center?
Correct.
The distance limitation works one way but not the other. So if it's a new liquor store, they have to meet that buffer requirement, but if it's a new FMB, they don't. There's a 500-foot for them and then 1,500 from the liquor store. So, but that's all stuff I deal with before you ever see an application.
Right.
And that will be in the staff report or the staff information.
Yeah, before you ever see it, we'll GIS it and make sure.
But yeah, there's
that they meet the
no
requirements.
foot buffer when you're talking about a service establishment like a restaurant or a tavern.
Yeah, they could be next door and on. With respect to medical marijuana, you can grant or refuse license, restrict or revoke, depending on the facts, and make any special rules as necessary with respect to control of the cultivation, manufacture, distribution, and sale. Now, certain of these things would probably be recommendations to council if it were to be something we needed to have. We'll talk about this in a minute, have council adopt an ordinance. Some cities like Greenwood Village has all sorts of limitations on how many plants in a particular area and, things like that, power usage and things like that because of fire code considerations. So if we were to...
And we do have some of that.
Yeah, so...
I was going to ask that question. What does Littleton have as far as someone that wants say they want to get a grow license? Do they grant them here? They're not
No.
granted?
We allow medical marijuana centers, dispensaries, no auxiliary businesses, no grows, no distribution, no transportation, nothing. Now, the dispensaries can use up to 10% of their space or 200 square feet for grow, and then they have a limit on the number of plants per patient that they can grow.
Do you know if any of our dispensaries are taking advantage of that, utilizing that allowance?
I believe at least 2 of them are. The third one, I'm not sure. Yeah, and then Paul, if I could just pipe in with one more thing. So the other thing that differs from a marijuana hearing for a new license needs and desires is not considered
Right.
for a marijuana license. It's not part of state statute. So while you have to hold a public hearing and give the community an opportunity to come out and speak either in favor of or opposition of, none of that is necessarily taken into consideration, like it would be for a liquor license.
Liquor has the state statutory component that we have to comply with. So, I mean, again, would it be licenses or complaints against the licensee, maintain records, and then develop forms, licenses, application, identification cards, you know, all that kind of stuff administratively, because it's all within the code. Okay? So, I think these questions are all good. It's related to these. So the policies are, with respect to medical marijuana and are set by the code by council, and then we have to operate within those parameters, okay? Because that's sort of our authority for the city. And if there needs to be changes to the code, we'll have to go to council to get those changed on our recommendation. And then we do have some oversight from council because they appoint you as members, and if for whatever reason they get grouchy with you, you might not get re-upped. So, now the staff meaning mostly Colleen, takes care of all of this sort of administrative stuff before it gets to you. So, you know, they process and review the applications, look for compliance. You know, if there's something that's out of line in the application, she will call that to their attention so that that's all fixed before it comes before you. So all of those sorts of things, she gets those ducks lined up before they get here. She does all the scheduling. She sends out the public notices. Somebody from staff will do a staff report. Colleen keeps the minutes and will provide assistance as needed, like a new password today. So stuff like that. So as things go in local governance, the charter is our constitution for the city. And that tells us how we're going to operate the government. And then under that, council adopts ordinances, which are our local statutes. And they have done that with respect to liquor and medical marijuana. So those are sort of our constraints. And as a home rule city, we don't necessarily have to follow state statutes unless there's a conflict. So if as in with liquor licensing, there's this state statute that sort of preempts the field and says you have to comply with all of these as part of being a liquor authority, we're going to have to fit within that box. But like Colleen was saying, with respect to medical marijuana, it's a little more of the Wild West, and so we don't necessarily have a series of statutes that we have to comply with. So council can adopt its own ordinances within its home rule authority for purposes of that, and then those ordinances will be what constrains your authority going forward. So there are some general ordinances, I didn't cite them here, but that sort of control how all boards and commissions within the city operate, including city council follows the same sort of process. And so I should have given you the site so that you can look at. Is it in their handout, Colleen?
I'm sorry?
The rules for handling, conducting meetings.
You mean the process?
Well, yeah, I mean, there's the general rules in the city code that have that stuff.
No, they do not have that, but I can get that for you.
Yeah, that's, they just, everybody follows the same sort of thing, okay?
Right.
So it ordered the meetings in certain parliamentary rules, and I kind of joke, you've got a copy of Robert's rules. The city's rules are more relaxed than Robert's rules, so they're more Bob's guidelines than Robert's rules. Okay? They kind of follow that format, but not as strict. Robert's rules can be really, really complicated.
So that was one question I had in the last one. We don't go to the chair when we're needing to speak or make a motion, or because in legislature I'm used to that. You go through the chair to be recognized. But we don't do that in our board.
Not strictly, it's maybe more of a making sure that everyone else has a chance to speak and
Just a little more informal, wouldn't you say?
Yeah.
Yeah, but it is the chair's responsibility to make sure that every board member has an opportunity to weigh in.
And so just flag as I'm going to take it and I'll point to you probably. I think that's what Bill and Andrew did before me, so.
But that doesn't mean that's what you have to do.
So you say.
Just saying.
I mean, I don't want to jump in without being recognized if you need to recognize us before.
Not necessarily, no. I mean, if you sense the lull and we'll take time. I'll try not to rush the meeting so that we can just have a couple moments of silence and then when you recognize that silence, just jump in with your questions.
No, I think the chair is responsible for making sure we have a record. And because there's, all this will be recorded and all of that stuff, we need to speak one at a time and make sure that there's, people are, whose name it is that's speaking and things like that. But other than that, I think you're right, it's much more relaxed as to who jumps in when. If the chair, says we need a motion on something, he's probably not going to wait for you to raise your hand and acknowledge it. If you say, so moved, or I move to approve the license, then, we'll just move forward like that.
It's been a long time since there was a heated meeting where the chair kind of had to take.
Correct.
It's happened.
It has, but this board actually tends to be, and I'm very proud of this, probably one of the most civil boards we have, because we really don't have those kind of.
We're really constrained by the rules.
Well, but even beyond that, I think that you all work really well together, and there's a level of respect and a demeanor that comes from that. So I'm appreciative of that.
I mean, everybody needs to be heard. And, we might not necessarily agree with what everybody says, but at the end of the day, all got the same authority as appointment from council, so you need to be heard. So stages of a meeting, and this is more of a evidentiary meeting. We get fact presentations, we get deliberations and fact finding. So presentation of the evidence by staff, the applicant, and then other interested parties in the community may speak. And during this point, you should avoid taking any positions and just ask clarifying questions. You're the judge. You keep a neutral, or the jury. You keep a neutral, fact-finding mindset and just try to, flesh out what all the issues are and where all the facts are and things like that. And then when you get to the deliberation stage, you can start saying, all right, now based on this evidence, I am convinced of these facts or of these issues, and then you can make a decision. Oh, there it is. So, my picture. Quasi-judicial means you're sitting in the role of judge or jury. You are applying broad rules and facts to a particular applicant or a particular property or a particular licensee. It would be legislative if you were making rules that apply generally to everyone. Okay? So in a quasi-judicial setting, geek out too much as a lawyer, but under the 14th Amendment it says no state shall deprive any person of life, liberty, or property without due process of law. We don't have the death penalty here, so we can't deprive anybody of life. We're not depriving anybody of liberty. We don't lock anybody out. But we might deprive them of a property interest or a property interest that they feel they should have. And so we have to give them due process of law with respect to that. That's what makes it a quasi-judicial hearing. So the city is one of the parties, and they'll make a presentation to all of the boards and authorities and commission on behalf of the city. The staff will do that. And then the applicant, the person that seeks some sort of relief from the board, it's either requesting some action or requesting some sort of remedy. So after you get notice that something's on the agenda, okay, you need to start behaving appropriately. Okay? We shouldn't go out and start gathering our own evidence, because what we're going to do is make a record at the meeting of what the evidence is. Okay? So now, if it's a question about scheduling or about who's going to be, or can I miss, all right, fine. But if you're not talking, as long as you're not talking about the substance of what's before the authority, then you can have those conversations. But if it's getting into those substantive kinds of issues, you shouldn't be talking to the applicant. You shouldn't be talking to staff. You should be making your decision based on the evidence presented at the hearing. Now, I think the Board of Adjustment does just a wonderful job of this. If you make an individual site visit, you just disclose it. If you've talked to somebody, you just disclose it. Now everybody has the same information you do. And you're making that decision based on everybody having the same information. So at the Board of Adjustment, it gets to that point in the hearing and the chair just asks, has anybody visited the site? And then people say, yeah, I drove by, or I live in that neighborhood, I drive by it all the time. And they just disclose that, right? And then, did you talk to anybody? And if so, what did they say? And almost never does anybody talk to anybody. But if you happen into somebody in the grocery store and they say, I'm the applicant, you disclose that, right? Now everybody has the same information for purposes of making a decision, okay? And let everybody know, both the applicant and staff, in case there's something that comes of that. Must be fair and impartial. Okay? Don't prejudge the facts, and then make the appropriate disclosures when necessary. This came up at council meeting not too long ago, where it was a hotly contested issue, and they were getting a lot of emails and stuff like that. So one of the things we could have done is made sure that any individual council member who got an email, we copied everybody on council on that, so everybody had the same information. Most of which was so much nothing, and then the applicant withdrew the application and it went away. So, we were looking for ways to sort of make the playing field more level, and then we didn't have to. So, the order of the proceedings is staff will go first, and then the applicant will preside, or make a presentation. The presiding officer then opens up the public meeting. Okay? Public meeting is just for anybody interested, neighbors, members of the community, anything like that, to give any additional information. Final presentations by the parties, and then close the public hearing. So that's the order, and then after the public hearing is closed, you go into deliberation and decision making, okay, by a public vote. So, item 1. Usually staff will have some overview. The applicant came in on this day, where the property is. There's usually an overhead shot from, Google Maps or something like that, where the property is. Summarize what kind of license, what kind of request. Identify if there's any issues or, ordinances or statutes that make a difference. Staff always makes a recommendation. Typically that is, everything's in order. Staff recommends that the application be approved and the license be granted. Okay? But this is your first opportunity to ask questions of staff. Okay, seeing the configuration of this property, is this, how is this monitored? Sometimes you say, what is the access point? I mean, there was in the last one, there was between a convenience store and a liquor store, and there was a door in between, and there was some questions about things like that. But they were clarifying questions, right? How is that managed? Who's on duty? And stuff like that. And then the applicant presentation, same thing. Okay? Usually they'll bring in new information. They don't usually repeat. But they want to, they're going to advocate for the position they want, so they're going to give a broader context to that. And then they usually have somebody who's conducted a survey for the needs and desires of the neighborhood, and they will present that evidence as part of that. Again, asking clarifying questions. All right, I think one of the questions last time was, how close were the people that were surveyed to the actual business, rather than, they have these sort of boundaries that there's, well, if they're surveying everybody at the edge and not somebody next door to the thing, does that make a difference in your decision making? So it was questions like that that I thought were completely appropriate. So you get as much information as you can. You're just trying to glean the information. Sometimes the applicants are, not so good at public speaking, and so you got to sort of engage them and draw some stuff out of them to make sure that you've got that. Often they're represented by counsel that will help them through that, which makes it go a little more smoothly.
Well, if I may, in my experience, and I've been on the board 4 years, for the new members, the applicants that have experienced liquor license attorneys make it much smoother because they know the process, they know the documents that they have to present, they know the fact situations they have to present, and it's not like pulling teeth. It's not like trying to get information out of them. They lay it out, and you are able to ask the questions, but there aren't any surprises. Now, sometimes we're able to ask the applicant questions about access to a cooler or locking or how many staff members on duty and all that kind of thing. But when there's an attorney present, it makes it go much smoother.
Yeah, there was good questions, I think, at that last meeting about what kind of training do you provide and, things like that. Usually that's in their application, but not always. So, I think those are great. When the chair opens it for public, for a public hearing, members of the public will sign in and say that they want to be recognized and want to speak. Generally, after everyone who's signed in has spoken, there's a general question, is there anyone else? Because sometimes something will come up from the people who've spoken and somebody hadn't signed up, but they want to say something. Usually get 3 minutes per person. So if they need to say succinctly. Sometimes that 3 minutes seems to drag on forever, but we try to keep it moving. And it must relate to the issue before the authority. If it's, that last time that woman wanted to talk about the zoning code, she didn't stay on it very long, so I didn't interrupt her. Let's just get it done. But if it gets off the beam, as to what's before us, and it's, needs and desires of the community, things of that nature, if it gets too far off that, then we really have no reason to consider it. Okay? After the members of the public speak, staff and the applicant will have an opportunity to say if they've got anything to respond to whatever members of the public said. Often they say no, but they have an opportunity. And that's your final opportunity to ask questions. So if the staff or the applicant says, no, I don't have anything to say, but something was raised in that, the public comment, and you want to ask questions, you could say, well, I have a question for the applicant based on what Mrs. Jones said or whatever. And that's your opportunity to ask those questions. At that point, we'll close the meeting. All of the evidence that will have been taken is now part of the record. So your decision will be based on what has been put into the record at that point. Chair usually entertains a motion, with respect to the application, to approve or deny. You need a second before you can move to discussion. Been in meetings actually recently where someone makes a motion, it gets no second, and it goes nowhere, and then somebody makes a different motion, it gets a second, and then that's when you have discussion. Now, this is your opportunity in the proceedings to say what you found persuasive, make your record as to why this is something that should be granted. So, usually, and you did a good job of this last time, Tim, is, kind of go through, member by member, discuss the relevant guidelines, what you found in the record or in the application to be useful, and in order to make the decision. And this gives us the basis that if there's a challenge, if you were to deny an application for whatever reason, and then the applicant sued and said this was improperly done, between the evidence and your deliberations, that's the record I can take to the district court and defend what you've done. So you need to make that record. Yes.
I know in the past we've had a couple situations where we heard a lot of evidence and we weren't entirely sure we hadn't really processed the information, and we didn't make a motion right out the gate, and we wanted to discuss first. Was that an error?
Yes. Yeah, there should always be a motion and a second on the table before there's additional discussion.
Now, what you could do is have a motion to suspend the rules, have discussion, or as chair, it's your prerogative, particularly under Bob's guidelines, to say, why don't we suspend the rules, have some discussion before we entertain a motion. And you can do that. That was actually at a meeting I was at, a couple weeks ago. It was exactly what the chair wanted to do.
And so I could just do that. It's not a
But
motion.
you have to make a statement that you're going to do
Yeah,
that.
let's suspend the rules.
I'm going to suspend the
And
rules.
let's have some
Let's have
discussion
some
before we entertain a motion.
All right.
And as long as it's clear what we're doing. And if it kind of gets off beam, then that's time for Colleen or me to say, all right, that's permissible, but let's say what we're doing. And we'll make a clear record on that. I'm kind of a stickler about that in court. I'm a real stickler about it. So if I'm making a record, it's not like I'm admonishing you. I just want to make it clear to preserve it that if I have to defend this in front of, a judge, that the record is what it is and that, everything's clear as to what we do.
By the way, if you make a motion, you don't have to vote for your own motion.
That is correct.
So sometimes you can make a motion just for discussion purposes.
Right, just to move it along.
Now, we have, one time I remember, and I think it was, 3 or 4 years ago, the public meeting was closed, and then someone tried to chime in, and the chair had to say, I'm sorry, the meeting has been closed to the public.
Right.
Right, and they've got to follow the rules. The public has to follow them just like you do. So legislative role, this board has very little. You make general rules and special rulings. I mean, it's in your mandate. I think you've mostly done that recently, so there's unlikely that you do that. And with respect to medical marijuana, but like I said before, that is the kind of stuff that applies to everybody generally, which would be legislative. If it applies to a particular applicant or a particular property, then that's quasi-judicial. So, I mean, and I think to the extent that we would want to make recommendations to city council to change the code for whatever reasons, that would be a legislative, so you would discuss amongst yourself, we wouldn't have a public hearing, we wouldn't take all those comments, we wouldn't take evidence, and then you would decide as a group, saying, we recommend that council make these changes to the code, and then council may have a hearing on that, or a study session, or various things down the road to see where it goes. Regulatory role, the only thing I could find is there was this provision that says you develop forms, licenses, and stuff with respect to medical marijuana. So there's not much that I would consider a regulatory role. Like the Historic Preservation Board has some more, regulatory kind of things that it does with its program.
We used to have, I don't know if maybe this is now out of the code during the last revisions, but we had auditing rights for books and records to
We
assure.
still do, that's in state statute.
Yeah.
So if our code is silent to it, then we defer to state statute. And the local and state authority have the rights to review the records and books of any licensee at any time.
Would that be regulatory, or is that, I suppose it would be?
It depends on what you find. If you're going to do something and try to limit the license or revoke the license, then that would be quasi-judicial. Now, it'd be regulatory as, for compliance purposes. Yeah, I mean, if you could do that, it would be more regulatory. That's not important. I'm going to just tag on a couple of things at the end of this about the open meetings laws, or the sunshine laws, as they're commonly called. A meeting under the open meetings law is any kind of gathering convened to discuss public business in person, by telephone, electronically, or by any other means of communication. I suppose if we had carrier pigeons running it back and forth, we could still be a meeting. Right? It's a very broad definition of what is a meeting. Now, a meeting occurs if there's a discussion about something that could require or could result in a formal action. Okay? And a quorum of this board, or 3 or more, whichever is smaller, would be enough to constitute a meeting and must be open to the public. Except, some things are not. Right? Social.
I'm sorry, go back. Is a quorum 3 or
A quorum of
4?
this board is 4.
Okay.
But for the open meetings law, it's 3
Understood.
or a quorum, whichever is fewer.
So if there's a quorum of 2, that would be.
Yeah, right, so, yeah, if we're a board of, 3, the quorum would be 2, right? So, social gatherings, or event, you said there was some.
Boards and commissions dinner tomorrow night.
Yeah, so you're all going to be there. Typically, it's noticed that there's going to be a boards and commissions dinner, and, if people want to see if there's any sort of business done, they have an opportunity to know that. They don't get to eat, but it doesn't mean that anything you discuss of public importance is part of the meeting or is forbidden. So, it's really important to the public in Colorado whether or not Flacco is the savior of the Broncos. That's of public importance, but it's not within your purview, right, as a licensing board. So it might be important, but you can discuss it. If you want to talk about some zoning issue that's important to the city, that's fine, because it's not part of what the licensing authority board has under its purview. So if there is an application pending, or if it's something that could come before the board, then you probably shouldn't discuss that outside of a meeting. And a meeting has to have full and timely notice, usually 24 hours. We usually do what?
We generally do a minimum of 48 to 72.
Yeah.
We try to post by Thursday afternoon for any meeting the following week, regardless of what day it falls on.
And there's various places it's posted. I mean, it's not just somebody with a thumbtack. I mean, it's on electronic places and the city's website, things like
We
that.
post on the city's website, the bulletin board in this building, at our municipal courthouse, and at the library.
Okay. So if you violate the open meetings law, the court can deem whatever action you took as void. Not only that, it could, whoever challenged you, would have to pay their costs. Now, not going to come out of your pocket, but the city would pay. So there's some consequences. Part of this, though, I think is for your benefit. If it's a public meeting and it's all recorded and everything's above board, then nobody can accuse you of any improprieties. And typically, if somebody starts talking to you about a license or something like that, you just, politely say, I really can't talk about this without having it at a meeting, because all of the members of the board have to have the same information. So I would save that to, discussion at the meeting, and just be polite about it. And then ask them if they think Flacco's going to save the Broncos.
So as a board, we revoke someone's liquor license. We are exempt from lawsuits, correct?
Right.
Personal lawsuits? Personal.
Right. Yeah, because you're operating
Right.
within the scope and
I mean,
Well, let's go back.
John Smith can't come back and say,
Yeah, so let's
Pete,
go-
Tim, Kenny, I'm going to sue you
No,
because you voted.
let's go back for a minute, though, what Paul was talking about. Let's say you're sitting around at one of these social gatherings that we've set
Predetermined.
up, right? And you get to talking and you say, well, I heard so-and-so did this and that. And well, if it comes before us, I think we should just yank the license. And then you do it in an open forum. I think that's a different issue. That's why it's very important when you're at these functions that are set up for you, or you happen to meet in public, run into each other at Smokin' Fins or over at Bacon Social or wherever, don't have those conversations, because then no one's going to overhear it. Littleton's a small town. Everybody knows everybody.
Yeah.
In case you didn't hear, my optometrist is Tobin's wife. I just found out. So so yes, Kenny, you're right. That's not going to happen. But if you have that conversation ahead of time and you've kind of come to a
Right, I'm just
consensus-
saying, within a meeting,
Yes.
we revoke.
Well, mean, it goes even one step farther. Not only does the city defend you, but you have governmental immunity by statute.
Right.
So, you know.
And if you revoke, you're going to be doing it based on the information that has been provided to you and within the purview both of our local laws and state statute.
And if somebody comes up to you, you know, before the meeting and says, I think you should revoke for thus and so, you stop them and then you disclose it to everybody else and said, I had this one conversation and somebody said this. Everybody has the same information. It's part of the public record and it's all a defensible action. Okay? It's a good question, though.
You're going to cover conflict of interest?
Well, if there's a conflict, I'm not going to cover that.
Oh, but it's the same idea. If you have a conflict and somehow you voted, it could overturn your vote.
Well, yeah, I was going to ask about if you could just briefly talk about when it would be appropriate to recuse yourself from a hearing. And it's my understanding that it's generally if there's like a fiduciary component to your vote.
If you've loaned them money, if they're a family member, you know, you have some vested interest in this that is personal rather than as a member of the board, generally you should disclose that. If it's personal enough, I think that you should recuse yourself. If it's personal enough and you don't recuse yourself, I think the chair could entertain a motion to say, you know, does the board think that this person should be excluded from the decision on this issue? Now, if we have a quorum when we start and we lose a quorum because the person's disqualified, I think you could still proceed with the meeting at that point. So, but I'm guessing that that's going to be a very rare occurrence. You know, if you've got, you know, that kind of interest. I mean, I suppose if it's, you know, next door to your house and you don't want it there, that could be something that
Yeah, you sign the petition in opposition.
I think a general rule is that if it has the appearance of looking bad, you ought to disclose it. Point of fact is, my office is in the same building as the Dill and Dill law firm. And I know I ride the elevator with those attorneys every day. So when I see a Dill petition come in, I always make a point to acknowledge that my landlord is Alan Dill, and I'm aware of this attorney, but I have no interest in this, and just put it on the record.
So is that what you were talking about, Tobin?
Yeah, conflict.
Something like that. And then, really good question.
One other point, if you do have someone come by your home to have you sign a petition, don't sign.
Don't sign it.
Don't take a stance and don't go on the record.
And you don't have to tell them why you're not signing it.
Right.
And then they'll just have you as an abstain when they
Right.
bring it to work. Okay, so just to be really careful, typically when you get sent out notices or your packets, Colleen will send it out so that you're all blind copies, so you can't respond to all, and we don't inadvertently have a meeting by all of us responding all and seeing something that's outside of the meeting. Okay? So we're not doing it because it's super secret, we're just trying to preserve the record for things like that.
Just to be clear, I mean, I think I know the answer. Talking about the proposed government action, if we are talking about scheduling the meeting, that's not something we have to worry about.
Right, because it's not substantive, it's procedural. But they're pretty careful about that. And, you know, I've seen lots of cities that are kind of lax on that sort of thing. And then you get a problem. And then it's like, all right, now what do I have to now sort of incorporate into our record so that we can proceed to make a decision? And that will be, you know, a call I'll have to make. But it's just, you know, social media makes it so easy for us to talk. Or if you're all Facebook friends and then you start talking about something that's coming before the board on Facebook, then all of a sudden it's like, ruh-roh. That's why you got to use these things, right?
Well, and there is one new form of social media you need to be aware of, Nextdoor. And the neighborhood scavengers put everything on Nextdoor, including a liquor license is coming up. So it's better to just not read that Nextdoor, ignore it, and move on. But there's been a lot of postings. There were postings on Nextdoor over the past couple of months over the, what's the social club?
Bacon Social?
No, the
Oh,
other one.
Social Bar and Lounge?
The Social Bar and Lounge. people, whether they were for or against it, they were just putting on there that, hey, do you know that space across from the old Albertsons is turning into a cocktail lounge? And we need to be aware of it, you know, where it is down the hill from us.
It's down in your neighborhood, Joe.
Yeah. And I should disclose it, it's my neighbor.
Oh, is it?
Yeah.
Okay.
Good.
Well, you weren't on the authority when you
I
came
was
for
not.
us, so.
No, but my point is that watch what's on next, or don't read what's on next door. Most of it's scurrilous anyhow, and not true.
Yeah, and you just don't want to create an appearance of impropriety, that somehow an influence is snuck into the proceedings other than what is in the meeting. I don't think there's any rules that we host a meeting electronically. I've seen some cities that will do that.
We try really hard not to do that.
So it's permitted actually for meetings of shareholders and things like that. Not board of directors. Board of directors can't have any meeting. So that's sort of it. One caveat, if you've got questions, generally run them through Colleen, since we are interim city attorneys and they're watching what comes to us. I get a request and I just answer it and bill for it. So if Colleen can answer it and I don't bill for it, then it's all better. If it's something that Colleen wants my answer for, then the city has got some control over how much stuff gets billed.
And it's possible that several of you can have the same or similar questions on something. And so, you know, it's just better to funnel it through my office. And maybe it's something we've already discussed and it just hasn't been disclosed yet. So I'll be able to handle that for you.
And sometimes what happens is those issues come up and then it becomes part of the staff presentation. And they will put that into whatever, the rules or whatever that applies, so that question will get answered. You guys make really good comments, really good questions. I'm happy to answer anything else if I can.
We've started doing the call for public comment on anything not on the agenda at the start of our meetings. And that's similar to all the other boards and
Boards and commissions follow council
yeah.
in their process.
Do those have to be on subject to liquor licensing, or can those still be free form for my neighbor got a cat and I don't like it?
I would generally, say, let me answer this too. One, it should be only stuff that's within the purview of the authority. If there's 90% of it that is, and then they start talking about their neighbor's cat, okay, that's going to take 10 seconds. It's not worth the fight, right, in offending somebody. Now, if it's something completely off beam and you need an enforcer, I'll do that, and that you don't look at doing that. Somebody can look at me, or the chair says, well, I really don't think that's within the purview, then I can jump in and I can be the bad guy. I'm happy to do that.
And then if it's on topic, but it's gone nasty or vulgar,
Well, I'm going to give you a script that's similar to what the mayor uses that talks about, you have 3 minutes and we expect comments to be civil. And you certainly can shut them down or give the videographer the thumbs up and he'll shut their mic off. You are not up there to take abuse, and our citizens that are viewing are not to be subject to that. We also have a panic button. If they get really out of control, we can have police in the chamber in seconds. So, which we have had to do on a couple of occasions for council meetings, but.
I would think it would be very rare that it would happen.
Yes.
Yes, but it could happen. I could see just a particularly controversial license. So, no, I represented the city one time, and it was after I left that city, but it was like a couple of months later, the 2 council members got in a fist fight while it was being streamed, on TV, and I'm like,
save it for pay-per-view.
that's right.
So I've only been to one meeting so far, so I've seen sort of that initial licensing process. How does the violation process work? Like if we're considering revoking somebody's license?
Oh, that's such a great question. So, we have a couple of potential potential violations coming before the authority next month. I know you're not going to be here. You'll miss the probable cause. So how that works is, and it will come to us in a couple of different ways. It will either come to us as a result of a compliance check from our police department, from the special enforcement team. And they have started doing compliance checks again, which is awesome. And had an opportunity to sit down with the officers and kind of go over expectations and those kinds of things. And our expectation is always to keep people out of trouble, right? So what generally will happen, it'll either come to us through a compliance check or as a result of the renewal period. I always ask for a report from our police department on anything that may have happened during that renewal period. Generally, I get police reports as they come in, and they just get put in a folder because there's nothing that would rise to the level of probable cause. In July, you're going to see two, one from a compliance check and one from a regular police report. Probable cause, you do not, I'm trying to think how to word this. The board does not need to see that there is sufficient evidence, just enough to move it forward to an actual hearing. So the licensee would be notified that you're going to discuss their license as probable cause. They can come to that meeting, but they cannot offer any testimony at that meeting. If you move it forward, then it falls into the hands of our city prosecutor, who will then take those facts as we have presented them and work with the licensee to hopefully come to some kind of stipulation and agreement for some kind of sanction, right? Oftentimes the licensee will agree to a stipulation because they accept that, yes, we sold to a minor, or we sold to somebody who was visibly intoxicated, or, whatever. Then what happens is we have what's called a preliminary hearing, where they come and we review that stipulation. They have a chance. The prosecutor will present the city's case at that point. The licensee or their counsel has an opportunity to present their side. You can look at it and decide if you want to accept the stipulation, if you want to modify that stipulation, or if you want to say, no, we want to see this go to show cause. If for any reason that stipulation is rejected or we don't reach one, then we will do a show cause hearing. At that point, the licensee and any witnesses can come forth. We would subpoena the police officers, those kinds of things. And it becomes an actual hearing. Paul?
Only at the third stage is the
Yes.
quasi-judicial hearing where you take the evidence. So I've done, in a lot of cities, the licensing authority is city council. They take both duties, right? And so there was a compliance check years ago there was one in Sheridan. There was, I think, 12 licensed liquor establishments, 7 of them sold to the underage person.
Oh my goodness.
So we got them all in. Well, we worked out a deal with everybody, and they agreed to a certain penalty, and then we brought that before council, and council said, that seems appropriate, and everybody got the same punishment, sort of thing. So, but only if that process doesn't, so a probable cause hearing would be, is there enough evidence here that we think we need to hear all of it and hear both sides and make a decision on this based on some evidence? And if you get to that point, there's no real percentage, it's not preponderance of the evidence, it's something less than that, but you think that there's really something here that we think, should be heard before the whole board, then you can move it forward to the probable cause stage, and then we can get to the preliminary hearing stage. If it's not resolved there, then we have a full-blown hearing.
One thing that helps me is to remember that during an action like that, there are, and we're taking evidence, we're at the show cause hearing, there's 3 attorneys in the room. We have a city attorney who advises us and corrects us on clarifications of law. There's a prosecutor who will be the advocate against the license holder. And then there's going to be the defense attorney who will respond to the allegations and evidence.
And the guidelines that I've laid out for you, I think Tobin's already flipped the page. There are some guidelines for penalties in there, whether it's a first offense, a second offense, how much time in between offenses, those kinds of things. How egregious was the offense, right? And Tim's been around long enough to see a couple that were fairly egregious, I think. And, you know, you have an opportunity to do some kind of summary suspension. You can suspend and hold some of those days in abeyance. You can allow them to pay a fine in lieu for days served, things like that. So you do have, even though the prosecutor will come to you with a recommendation, you are not obligated to accept that recommendation.
And in the course of the hearing, I mean, I've seen this done several ways. Like, I'm the attorney for the Personnel Board for the City of Westminster. The chair in that case, because the chair and the board members want to hear the evidence, if there's rulings on evidentiary issues or things like that, that's just all delegated to me, and I handle it. What could happen is if those objections come out, and this is up to how you want it to be handled, is I can then give an explanation as to what the rule of evidence is, what the objection is, and then we can allow the chair to rule. We could, you know, if it's something that somebody says, no, I really want to hear that evidence, we might have to have a motion on what we're going to do with respect to that particular issue. If we get to that, we can get through it and just decide. Typically, you know, if I'm, you know, kind of sitting as judge and ruling on evidentiary issues, I usually will make an explanation. You know, somebody says that's hearsay, and then I'll say, well, wait a minute, you know, there's an exception to hearsay rule. It's this, and explain what that is so that you can put it in context under those circumstances, and then give it whatever weight you deem it's worth.
Are we bound by traditional rules of evidence? Or?
Not bound by, but the rules of evidence are there for fairness of the parties. Our rules will be a little looser than that. We will accept some hearsay.
We don't want to scare you guys off, but in the past 5 years, we've had one full-blown show cause hearing. We've had a number of spot, one-night revocation or suspension hearings for sales to minors and that kind of thing. But we've only gone through one full-blown hearing.
That was 4 nights of our lives. We'll never get that.
Just
saying.
And the licensee trying to hold on to his license. And it turned into a full hearing.
Mm-hmm. Yeah.
Well, if we get to one of those, we'll have a meeting, just us, not public, and we'll go through how we're going to handle all of that, and we'll prep for it. We'll be ready.
On a show cause hearing, I'm going to repeat my question again from earlier. I'm sorry for that, but prosecutor presents their case, defense presents their case. There's no public hearing. We're not taking anything else unless those two bring the evidence. At that point, they've both rested. We still need that motion first before we discuss, or in a show cause hearing, can we discuss before a motion? Or do I need to suspend?
I would suspend the rules before you have, because it's a public hearing, regardless of the meat of it, regardless of whether you're making a decision to issue a license or instill a penalty. It's still a public hearing, right?
And you could go into executive session if you need advice from your attorney on something like that, and, you know, you can come probably in this room and not record it. Well, we record it, but
Yeah, but it
part
would
of
be
the
a
public
voice
hearing.
recorder.
Yeah, and, you know, if there was issues like that, legal issues, or you want advice from your attorney, we could do that separate, but you have to have your deliberation and vote in public. It's got to be a public decision.
So what is next month is a probable cause hearing?
Okay, well, since the licensees have not been notified yet, I don't really want to talk about it in public forum. But they will be notified within the next day or two. And then when packets go out to you, you'll have all the information. And just because you won't be at the meeting doesn't mean you won't get the packet.
Understood.
So you'll have everything. So yeah, I don't want to discuss it too much.
Do we have any new applicants?
Oh, we do. We will have, at the July hearing, we will have one new application, and in August, we will have one new application.
And that is, if I may, we always ask Colleen at the end of our hearing, what's coming up, what's in the pipeline, because it helps to know. I mean, as she said, this is a small town, so you're driving down the street and you see our big notice up, or you see somebody remodeling a bar or a retail establishment. The next thing is, oh, that's gonna come before us, I better pay attention to it.
And on that note, if you see someone remodeling a bar, you know what, maybe just reach out to me and say, hey, what's going on at this location? Because sometimes they haven't gone through the proper process, and they're remodeling without any kind of permits, permission, and they haven't requested modification of premises. So sometimes I find out about that after the fact, and we need to kind of slow their roll and get them back up to compliance. Because again, our goal here is to keep our licensees compliant. We don't want to see them for show cause and probable cause.
And I wasn't aware, we had a liquor store that moved just a couple doors down, and he had to come to us. And I wasn't aware that that was the case, but.
Yes, if they move
Particular square
locations.
footage is.
Right.
Is licensed.
He just moved like 2 doors down, did he?
And now
Yes,
he's
he
open.
did.
Now he's open, yeah.
Yeah, now he is open, that is correct. But yeah, if they move location, if they substantially change the footprint
Because
of their
we
licensed
licensed the
premise.
location,
We
correct?
license the entity at the location.
Right, yeah.
Right, so that license covers both. So the entity can't just pick it up and move, and they can only move within the jurisdiction that they're licensed in.
Just like a bar can't put on a patio, they
Without-
actually have to license that for liquor
Yes.
in that patio.
Yeah, so any substantial modification, I don't care if they change their paint colors, I don't care if they add a couple of extra tables. I do care if they move the bar from the left side to the right side or to the back. I do care if they're adding square footage. I do care if they're changing signage, which we have seen by driving down the street and going, well, that's not right. And then you find out that, oh, it is under new ownership and they never filed paperwork. So because I'm not out there all the time, if you see something that looks different than the last time you went by, just shoot me a quick email, pick up the phone, pop in and say, hey, what's going on in this location? If I know about it, I'll tell you. If not, someone's getting a phone call.
And just to clarify, the new building that's going up in Littleton Village, that's a Culver's?
Culver's. And I believe there's supposed to be a Denny's over there too. Woo! Just saying.
We want their town center.
Yeah, we did have, and I won't go into detail, but we did have a prospect come into town last week and look at the West Littleton location that has previously been Dee's Tavern and Pinocchio's and Del Vecchio's and was it the Crestwood 100 years ago?
Yes.
The Crestwood forever.
Well, that's,
Right.
so we did have someone come in to look at putting in another kind of family restaurant with a focus on steakhouse. So would be super exciting if they came in, but I'm not going to say anything else. I have one in my town, so.
Is it common on these permits to put in like specific stipulations about their operations or anything? It's probably not, right? You have a recommendation, you either go with it or you deny it.
Give me some more, like,
Well, I don't
what are
know.
you talking
I
about?
was just, well, so for instance, the guy with the divider between, you know, his, he had one side with liquor and one side without, and we were asking him, you know, you're gonna have 2 employees? Is it gonna be 1? So
And I
is
think
there,
that's appropriate.
but do we put anything in their permit about that? Or like
No.
coming back and when they say their employees are trained to be these
Okay,
providers?
so under state liquor law, there is no requirement for alcohol servers to have any kind of tips training or anything like that. It is certainly something that you as an authority would have the purview to request, or in the case of a sanction, you could make that part of the stipulation. You could say, we want to see, and we have done this in the past, proof that all employees involved in the sale or service of alcohol complete a responsible vendor type training within 30 days, 60 days, 90 days, whatever that is. That can always become part of a stipulation or a penalty.
Do you ever approve a liquor license provisionally? Have you ever done anything like that where it's some sort of a limited approval because there's some concern? Or is it always just on a sanction level that we would do something?
Right.
Like we would renew provisionally, I think, tax issues, I think.
Right, so those are some of the issues that would come up at like a pre-renewal hearing, right? If I find out that they're delinquent on sales tax or something like that, or if I find out that they've been getting their alcohol from the liquor store next door because they know the guy that owns it and he gives them a really good deal, but they're not really getting it from a wholesaler or distributor. When I find that out at renewal time, then it becomes a pre-renewal hearing. We determine if we really want to move it to a renewal hearing, and at that point we can decide, are we going to renew them or are we not, right? So that doesn't become a revocation, it becomes a non-renewal, right? And the license is dead. There have been instances where we have held renewal hearings, and one of the requirements for renewal was that a particular person on the license be removed from the license. So you do have those kinds of things you can look at, because maybe it is one of 3 people on that license that have more than a 10% share of the license that is really causing all the problems because they just don't want to play by the rules. You can make that part of the requirement for renewal. And then they would have to show us proof that that person is no longer part of that LLC or corporation.
When we are going through our packet, getting ready for the meeting, and we notice something is missing, we can direct that question to you. And if it's something that needs further clarification with the applicant, you can have that conversation.
Well, see, and I think that because we do get your packets out to you early, I think that that's a perfect opportunity when you're reviewing it. If you have those kinds of questions, shoot me an email and just say, hey, on this page or in the staff report, I have this question. And then, I can chat with Paul on how we want to address that. It may be as simple as, and we do this for council, putting together a memo for you before the meeting with all of the questions that have been asked and the response to those questions. So you all have the same information going in, right? You're not sitting up there going, oh, I was going to ask that too. You all know. And then it becomes part of the record once we're in the meeting.
But if it's one of those things where you get your packet and it says, in the application that there's an Exhibit A, and then you're like, I don't have an Exhibit A, it may not gotten attached to the email or something like that. Something easy like that that's, not substantive. I think that's perfectly appropriate to call in, and it may have to happen with everybody.
Right.
It does help to have the layout and the map.
And you will always have the diagram of what we're licensing.
Part of the process.
Yep.
Excellent questions.
Did you want to go around the room, or do you think we've accomplished that with questions? Or
Does anyone else have any other questions that they've developed? All right, I think that's, we think the...
Well, do we want to go down and do introductions since we have some new folks? Do we want to do that?
Let's just go around the table real quick. We'll start with Jyoti.
Hi, I'm Jyoti Ravindran. I am new. This is my first meeting. I'm an attorney for Children's Hospital, Colorado.
Have you ever served on a Littleton Authority or board
Nope, I
commission?
have not.
How long have you been in the city?
I've been here since July of 2018. I lived abroad for 5 years, and before that I lived in Evergreen.
Okay.
Kenny Schock, I've been on the authority, I think this is my 5th year.
I could look it up for you.
I think it's my 5th year.
I'm Mike Buchanan. I've been on the authority since this authority since 2015. Prior to that, I was on the Englewood Authority. I was there since 2007, so about 12 years on. I'm an attorney, and I work for the U.S. Department of Agriculture.
My name is Tim Levere. I am the chair currently for this authority. I have employment with Western Union. I'm a compliance professional for anti-corruption. I have been on this authority for 6 years. This is my 7th. And prior to this, I was on the Parker Authority back in 2008 and 9.
I'm Pete Webb. I own a strategic communications firm in Denver. And I've been on this authority 7 years, believe it or not. I'm a former chairman of South Metro Fire Rescue. I was on that board for 8 years. And my firm runs a couple of programs for the state of Colorado, the No DUI Colorado campaign, and the Persistent Drug Driving campaign, and the Prescription Drug Abuse Prevention program with a consortium.
I'm Tobin Fullenweider. This is my 2nd meeting on the authority. I haven't been on a board before, but I worked for a state board for many years, which Pete knows, State Land Board. I work for the Department of Personnel Administration. I'm the Deputy Executive Director.
My name's Mike Eamon. I work for Jefferson County, so I'm a Business Services Coordinator for the Business and Workforce Center, and this is my 2nd meeting.
Anything from Beth?
No, we talked about, Pete asked about business upcoming, which I had on my list to talk to you about. So we do have a meeting in July. Tobin will miss that. We will have a meeting in August with a new one. If we find that there is probable cause in July, then August is when the preliminary hearing would take place. September is when show cause would be scheduled. If we have a preliminary and we accept the stipulation or accept a modified stipulation, then the show cause date is vacated at that point. And then just a reminder again, we do have our authorities, boards, and commissions dinner tomorrow night, 5:30 at the museum. It is a Polynesian theme. We hope to see you all there. Communications usually puts on a nice little event for us, and wear something classy Polynesian or something tacky, whatever. I might be wearing pink flamingos with palm trees. I don't know yet. So just say it. That's it. And then I need to see Josie after the meeting for your iPad. That's all I have.
Thank you for the presentation.
Yes.
Oh, and I will,
So they had so many lawyers.
if any of you want, I will give you a PDF of Paul's slides, if you want. I'll just send it to everybody. I'll send it to everybody. I'll do it.
Thank you all. I think we are adjourned.
Thank you. Anybody else need for a second?